5 minutes past 10, our talkback lawyer David Whiting is here in the studio to take your calls, helping you with free legal advice. 1300 222 774 is the number, 1300 222 774. And David, good morning to you.
Good morning, John.
A couple of things around at the moment. I noticed there was an inquiry being conducted yesterday into the future of police complaints against police officers. A couple of submissions from interested parties, including the Police Association and community legal centres, and also a private law firm. 90%, I think, of complaints against police that come to IBAC are sent back to the police to be investigated.
Yeah. There was a suggestion from the Police Association that there was a large proportion of them that were like tit-for-tat complaints. So, you might get charged and you then make a professional standards type complaint against the police. And
it works both ways. If you make a complaint against the police, you often find in retaliation you get charged.
The hamburger with the lot.
Yes. Assault police, resist arrest, offensive language, and two police corroborating each other's version of events against yours.
Yes. So, every now and then you'll see someone who might well be a charge of assault might be appropriate, but that just gets bundled with a whole series of other ones.
People don't realise that assault police can mean as little as shouting at a police officer.
Yes.
That can be an assault.
It can, yes. But there needs to be
an
apprehended
apprehension of violence.
There needs to be an apprehension in the police officer.
Yeah, and resist arrest can mean as little as saying, no, I'm not coming with you.
Yep.
Why should I?
Yep.
And that's if you yell at the policeman and say, leave me alone. No, why should I? When they say get in the van, that's assault police resist arrest.
Mm-hmm. Well, resist arrest probably, but I don't know about assault police. So yes, it is a fairly gentle line you cross that might result in a whole series of charges. I think, John, if you want someone to investigate police, then it really can't be the police. Isn't that the problem? Isn't that why we've had a police ombudsman and then why we've now got... Well, that's why we gave the job to IBAC, isn't it, in a sense? It was the ombudsman had the job, then we split it. Now we've got this.
In 1985, when Steve Crabb was in Jon Faine's government as police minister and I was working at Fitzroy Legal Service, which coincidentally we celebrated the 45th birthday of Fitzroy Legal Service and the 40th anniversary of what's now the Law Handbook the other night, which was good fun. But when I was at Fitzroy, 84, 5, 6, 7, Ian Freckleton, who's just been in the news doing the investigation into Robert Doyle. Ian Freckleton was the research lawyer with Hugh Selby at what was called then the Police Complaints Authority that was set up to be an independent monitor of police. That failed, and the Police Association or the Police Union back then, they basically did it in by saying we won't cooperate because we don't trust it. We've tried every different method of doing this job. So, I don't know, do we go around this debate again?
I think if you can't solve it, John, you can't hide it. You've got to keep trying to work it.
Okay.
Right, so it will continue. So, yes, the answer was that, the suggestion from the private lawyer was that there were matters going back that were in fact being sometimes resulting in extra charges being laid, all of which is a particularly unsatisfactory process. A couple of other things in the news, John. Banksia it started life as a thing called the Schmick, a solicitor's mortgage investment company. Because lawyers, lots of law firms used to run mortgage portfolios. They were, in a sense, a third line lender.
So a client's got some money to invest and the solicitor says, well, I know some people who want to borrow and I'll take your money and lend it to another client and I'll take a cut.
And generally it worked. Yep. But when it failed to work spectacularly. In this particular one, it went under into, and it changed because the laws changed, but it changed and became a standalone entity, but effectively they were the same lenders and the same kinds of borrowers. But it went under in 2012 owing $660 million.
That's a lot of money.
It's a lot of money. Well, everybody would appear to have got back some... about 76 cents in the dollar effectively, which will have hurt because, John, you haven't seen your money for 5 years.
Number one, and number two, you're only getting 3/4 of it back and no interest.
Yeah, well, there's some more money as a result of some orders made in the court during at the end of January, but for which reasons were published on Friday. So it'll get a little bit better. And you could expect, if you're a party to that, to expect some kind of settlement proposal shortly. 7-Eleven franchisees are filing a class action lawsuit against the group and the ANZ, and their arguments in part are that the ANZ made unsustainable loans and breached the code of lending to would-be franchisees and giving them hundreds of thousands of dollars they couldn't afford to repay. The statement of claim, 110 pages, was to have been filed on Friday, so I imagine that it was.
110 pages, and a lot of this arises from the investigation into wages fraud and theft.
It will have come out of that,
right,
and might well have come out of cancellation of franchises as a result of the wages fraud issue.
All right.
That's about it.
That's a fair bit.
It's busy for, they're not my clients, John, but it's busy for lots of people, yes.
Let's get to today's callers, 1300 222 774. Kevin in Ballarat's first up, and Kevin, good morning, you're through to David.
Good morning, David and John. My question is, my stepson, I wanted to see about changing his surname to my name.
How old is he, Kevin?
Well, he's getting pretty old now. He's 44, I believe.
All right.
Yeah, 44.
Then let's be honest, Kevin, you can't do it, but he can.
He can.
He can. He goes down to births, deaths and marriages. I now want to be Kevinson instead of Johnson, and the paperwork happens.
Okay, so simple as that.
It's as simple as that. You then got to start doing things like getting your licence fixed. You need a new passport. There are those issues that need to be addressed. But in terms of change your name, you go down to births, deaths and marriages at 600 Burke Street or 610 Burke Street, and you change your name.
So yeah, cool.
All right.
Actually,
so perhaps he's been ducking for 25 years, do you think?
I don't know. It's just a sort of thing that originally there was all this, it's too difficult, you can't do this. This was years ago.
It was more difficult than it is now, but the process now is you just go and get a new birth certificate.
He had a very close relationship with his grandfather on his mother's side, and he thought, well, maybe he'd prefer to keep it that way. And then of course, he joined the armed forces under the surname of Charles, and he got his licence under the surname of Charles instead of his. But yeah, anyway, so I don't know. I thought maybe it automatically.
Well, it would be really nice if they all tied together in some way.
Yeah. Okay.
All right. Particularly now, as identity and identity fraud is so prevalent that if he locks into one, it's going to be much easier now than it will be in 10 years' time.
All right.
Oh, yeah. Okay. Thanks a lot for that. Good on. All the best.
Wendy in Heidelberg. Hi, Wendy.
Oh, hello, John and David. I have a query in relation to a developer next to our house. When he started the development, he knocked our fence over. I actually spoke to the developer and he said, oh, look, don't worry. At the end of the job, I will replace the fence.
Did it fall over accidentally or they deliberately demolished it?
It was when they were excavating.
Right.
It's much lower. The yard is much lower than ours.
Yes.
And the fence just fell over.
Okay.
Sorry, then we're starting to get tricky at this point.
Okay.
If the builder pushed it over or caused it to fall, then the builder has a responsibility.
Okay.
And the person that you talk to is not the developer, but the person who issued the building permit.
Okay.
Because there will be a person who's responsible for the building and complying with the laws relating to the damage to adjoining properties. And the issue there ought to be a barrier between the worksite and your home, and there now isn't.
Oh, well, there is a fence. He's propped it up. It fell over, and then he's propped it up just during the work.
Yes.
I mean, I could just easily push it over if I wanted to. But I have spoken to the council, and they said that unless it's on the building permit, they can't do anything about it.
Yep, and it won't be.
No. And when do I have to wait until the building has been, or the work has been approved, do I?
No, you could do something about it now.
Okay.
So you could, what the question is, though, Wendy, how much do you have to pay? Because if the fence was about to fall over, it's not logical to require the person next door, who's the owner, not the builder, no logical reason to ask that person to pay for the whole of the fence.
No, it wasn't ready to fall over. We'd not long ago done renovations and we put a new fence through. maybe 5 years ago.
So it's only a 5-year-old fence. Then what you're asking your neighbour to do, who's the owner, not the builder, to reinstate the fence. Because you've told me, well, you're a little bit wishy-washy in what you've said.
Okay.
It either just fell over or the works being done next door caused it to fall over.
No, the works next door, when they were excavating,
Yes.
they disrupted the
close
foundation.
Then it's their problem and they need to fix it. Talk to the developer. But if the developer's going to give you a new fence in a few months' time, that's better than you having to argue how much you ought to contribute.
Text. I hope that helps you, Wendy. Text messages galore. Births, deaths, marriages, 595 Collins Street, not Burke Street, I think you might have said. So 595 Collins to the half a dozen, including Stephen from Williamstown, who have sent us that correction. Thank you very much. Robin Clayton, you're through to David. Good morning.
Good morning, David and John. I hope this is a fairly easy one in sort of a two-part question. I've got the opportunity in looking at acquiring a whole small tool room of used equipment and the rights to the little nostalgia product. So it's being sold as a parcel, machinery and rights, designs and website, existing stock. And I'm wanting to know, is that just a simple contract of sale? How do I protect myself for clear title of the machinery and not inheriting a whole lot of legacy warranty issues?
Okay, will you avoid the legacy warranty issues by not buying the business, but by not buying the entity that owns the business?
Okay.
All right, so next thing you do is you have a look on the Personal Property Securities Register. And you can log in and pay a fee, and you want to see if there are any charges registered on the register.
Against the name of the business or the individual or both?
Well, whoever owns the business. So if it's Fred selling, you can search under Fred as an individual. If it's XYZ Proprietary Limited, you can search under XYZ Proprietary Limited.
It would be prudent to do all, wouldn't it?
Well, no, I don't care what Fred's encumbrances are if XYZ is the seller, but I would be searching both the Australian company number, if there is one, and the Australian business number.
Which may not be the same.
Because they might be similar, but they definitely won't be the same. And it's possible...
They've got like a different number at the start or something.
No. See, that's where everybody falls over.
Thank you.
If it's an Australian company number has 9 digits, if the Australian business number, which has 11 digits, has the last 9 the same, but 2 extra at the front, then it's a company carrying on business in its own right. If the 9 digits at the end do not match the 9 digits at the end of the ABN, so in a sense there's no link, then the ABN has been issued to a trust or a partnership and not to the corporate entity. So you would search. So if XYZ Proprietary Limited is trustee for the DEF, I'm avoiding ABC for obvious reasons, the DEF trust, then the company would have an ACN, the trust would have an ABN, not an ACN, and you would search both of them to make sure they're covered. Now, that's a long way through, Rob, but does that help?
It is.
Right, now, what you then need to do is that if he's got any registered designs, then your documentation should make reference to the designs, but should also assign the intellectual property rights rather than the mould, or rather than just the mould, or whatever it happens to be.
Or the patent. Rob, you're presumably investing a fair bit in this little venture.
No, it's a really tiny, this is like nostalgia, tiny little model aeroplane engines. You probably sell 10 of them a year. This is an indulgence on his part and indeed on mine.
So you don't want to invest money in getting proper legal advice because it's not a commercial transaction?
Well, look,
it's more a hobby.
It's a hobby, cottage industry at best.
Yep.
And so I want to go the path of least resistance without exposing myself to
you just make it clear what you're buying.
Yep.
And you do so. For example, you wouldn't buy the shares in XYZ Proprietary Limited because then XYZ has got the problems. So you're buying the stock. You're buying the
machinery
and equipment that makes it. You're buying the intellectual property that goes with it.
The goodwill.
You're buying, But my guess is that Rob's not going to be paid. You would normally buy goodwill in a business, but I'm presuming there's very little goodwill in this deal.
Goodwill here would be, what, a list of previous customers and suppliers, for instance?
No, that's a list. The goodwill is the difference in value between what you pay and the value of the material assets. So if you were selling a business that had some stock, a shop, for example,
yep,
you would be buying the stock, you would be buying the fitting,
yep,
you would be taking an assignment of the lease,
yep,
and we would call everything between the total of those and what you were paying as being goodwill, and included in the goodwill is the client database, the likelihood that a person will come back. And technically, you can't buy a website, but what you do is you still take an assignment of the website.
All right, Rob.
Thank you very
Rob.
much, gentlemen.
Sounds like good fun. Go to it. Carolyn in Doncaster, good morning to you.
Oh, good morning, John and David. We recently received a claim through a no-win, no-fee law firm for an injury. In the midst of the negotiations, they had to change our lawyer, which they did. And when that person took over, they claimed that as long as we didn't have to go to mediation again, we wouldn't be charged any further. Now, we've since received an account of sorts, and it looks like they have charged us an extra $15,000 or so.
Then, if you've got an account from them, Carolyn, there's a person's name on the account as you contact if you've got some concerns. Do you have any documentation as to the no further fees?
No.
Is that in an email?
No, it was verbally over the phone.
Yeah, okay. That's. I always like to confirm those by email when somebody makes a call like that to me. So, but there's no reason why you can't go back to the law firm, to the person whose name appears on the account, and say, we had a discussion with X on or about this day, who said that if there was to be no mediation, there would be no further fees, and that we effectively have accepted the offer on the basis of that assurance.
Yes.
So,
and how detailed should that account be? Because it's all gobbledygook to me.
Well, it's partially a mess. The law says that you are entitled to an itemised bill, and the itemised bill ought to list everything that they've done, and if they're charging on the basis of time, how long everything they did took. So there's from our point of view, we look at a Queensland case in the District Court where there was a lawyer working on a particular matter for a particular client all day, and he or she simply said, 7.5 hours or whatever it was, and I did the following things. And the client went off to the court and said, yes, but we don't know how long this lawyer spent on each of the tasks, so how do we know whether the amount is reasonable or not reasonable? So you are entitled to an itemised bill, but if you're on a no-win, no-fee basis, you need to look and see how they are charging you as to whether that matters, if that makes sense. So you need to look and see what's the basis upon which I'm being charged, and will it make a difference if I get an itemised bill or not. But whatever the law says, you are entitled to a breakdown by task and time.
All righty.
Okay, lovely. Thank you for your help.
And I hope you actually get something at the end of the day is the point of it all.
Well, we have, but yes.
Slightly less than we thought.
Yes. The extra 15 would be a great help.
It would make a huge difference, but that's kind of, the equation works, I think, doesn't it, Carolyn, that you're getting something you would have not got at all if not for this method of getting to sue.
Yes, true.
Yeah.
True.
So,
And it's also possible, Carolyn, that a great deal more work was required, not just a absence of mediation. I don't know, but you should have the discussion.
Thank you for your call. Jeanette in the city, good morning to you. You're through today.
Oh, good morning, John and David. I have a question regarding a probate and a will.
Yes.
And a requisition notice. There are several beneficiaries, three of whom were nominated as executors, two of whom accepted. The third party didn't, and we're very relieved because his clause is not really regarded as fit to execute the estate. But
I say the beneficiaries are pleased the third person didn't. Is that right?
The beneficiaries, and the current executors.
Okay. Okay. They're happy that the third person didn't sign up. Yes. Go for life. Yep.
And now, and because there was a will he'd produced, which was not a proper will, so there was some concerns about his behaviours. Anyway,
this is the deceased, not the third person. Yep.
The third person. Sorry, the third person had produced
a will,
a later will, which is now resolved from using.
Oh, glorious! Yes.
And so the probate has been granted for two parties.
Right.
Well, hang on. Did you bring the will produced by the third party to the attention of the court?
Yeah, I think that was written into the affidavit as well.
Okay, all right, because I've been down that path and it's messy.
Can be incredibly.
Yep.
Your question today then, Jeanette?
So the question today is, now that third party, given that the earlier will has been recognised, the third party wants to come on as an executor, and we can't work with him.
It's not your choice.
Okay.
If the third person has renounced probate, they can't come on.
Okay, so he renounced it in writing to lawyers, but now...
No, there's a technical document with which that you renounce probate.
Right.
So if the probate says probate is granted to A and B with leave reserved to C to come in and... Okay, then he hasn't renounced probate, he's just not applied. He can now apply if he wants to, and it's not your choice.
Right, and so I noticed that you can declare somebody unfit to act as an executor.
Jeanette, why don't you try really, really hard to complete the administration of the estate and render him irrelevant?
Exactly so, yeah.
Is it a complex estate, Jeanette? Are there...
It's just that this third party also is making all sorts of particular claims.
But is it complex? Are the assets...
No.
Are the assets liquid, or are they...
Yep, we've done everything. We've prepared everything. We've just...
And how long ago was probate granted?
3 months. And, the other party died 18 months ago.
Right, but you got probate 3 months ago, and you've collected everything, and it's sitting in a bank account.
And proposed to distribute it equally amongst the parties as the will says. But
right, now stop there. Is the third person making a claim?
Yeah, making lots of little claims.
No. The answer is the third party, we'll call C for the sake of the discussion, has that person said, I propose to make a claim against the estate for further provision. I want more.
He's said it in terms of making demands on it. He hasn't produced a par for, we don't know.
Okay, well, I think it would be unwise for you to distribute assets.
Yeah, we haven't. No,
all right.
We can't. We're not.
So, but if you've got it reduced to a single bank account, you actually reduce the ability to have an argument.
Have these demands been made in writing, Jeanette, or just oral?
Yes, yeah. No, there's a number. He's produced...
Jeanette, the problem is that once you as an executor have notice of a claim, you need to administer the estate having regard to the claim. You don't have to admit it, but you do have to recognise that somebody might come knocking on the door and asking for money. And if you give away the estate too early, you may become personally liable.
Can you do an interim distribution, though? You can make a provision. Can you make a provision and say, well, your claim against the estate is for a maximum of X dollars. We'll distribute everything and keep X dollars in trust. We'll have an argument with you about the X dollars, and if we win, we can continue to distribute, but we've got it there in case you win.
If you're able to quantify C's claim, then my suggestion is that you would the answer is to what John's saying is yes, but I wouldn't be setting aside X. I'd be setting aside X plus a couple of allowances for legal fees.
Yep.
Yes, right.
All right? So, I don't know, let's say there's $1 million and C says, I want half, not a third, then the claim then becomes $140,000, $160,000, and you might say, well then, why don't we keep $500,000 and distribute the other $500,000?
All right.
Yep.
All right, so,
but
sit down with your lawyer.
What's the time frame when you see the requisition document?
The requisition document is a document issued by the court saying you've lodged a document, it's not perfect, please make these changes.
Yeah.
How did you get to see the requisition document?
The third party just emailed it to us.
Okay.
Well, then the answer will be well and truly underway. So,
Underway?
what's the time limit for responding? There technically isn't one.
Yeah.
So I've had requisitions that I've been able to answer in an hour, and I've had requisitions that have taken me 3 months.
Yep.
So
Depends how complex the questions are and all the rest
So
of it.
I would be
Jeanette,
sitting down with your current lawyer.
Have you got a lawyer, Jeanette?
No, we had to let go of that lawyer because there was just this third party was...
Okay, so
Okay, then go and see someone else with your co-executor
Yep.
and sit down
Start
and
again.
say, is it possible to make an interim distribution in these circumstances, and if so, what might it be? And at the moment, the two of you have control of the funds until such time as C becomes a co-executor with you. And it's the law is a bit strange, John. If there are multiple executors, in the collection phase they vote by majority. In the distribution phase it needs to be unanimous.
Okay.
So right here and now, while they're collecting, the executors to whom probate has been granted can act by majority. There are two of them. They're thinking the same. But when you get to a distribution phase, you cease being an executor. You're now a trustee, and trustees need to act unanimously.
So everyone needs to be in
be
accord.
very quick, Jeanette.
And you need specialist advice, and ideally, David, from someone who's dealt with estates and conflicts in estates before, because you wouldn't want someone advising you who's doing this for the first time.
No.
Although somebody
has to at some point.
Eventually, everyone who's doing it has to do it for the first time.
I want to get a job, but I need experience.
No,
well, where do you get experience? Oh, you get a job.
You do it under
there.
you do it under supervision, but if there's a sizable amount of money involved and all the personality issues involved, then these are delicate matters, and we will only be seeing more of them in the future. With an ageing population and the baby boomers coming through.
All needing money.
Yeah, well, claiming to need. I think
Is there a difference, John?
wanting more than needing.
Is there a difference? I
Yes.
mean, your children don't know the difference between want and need, do they?
I think mine do. I don't know about yours.
Oh, well, mine does, but, it took a while. Thank you, John.
That's the start of another whole conversation, but maybe not for today. David Whiting, and maybe not on air either, David. David Whiting, our talkback lawyer.